Hey, good morning, America. Good evening, India. So, this is Sean Shankaran, founding volunteer, Bharat Ki Awas, General Secretary, Indian Overseas Congress. Today, we have an august guest, Manish Tewari, former Union Minister for Information and Broadcasting, with us to talk about the new criminal code acts and what may be the impacts and maybe a lot of autocratic behaviors which we are seeing or worried as a society and as a party. So, looking forward to hear from Manish. Um Thanks, Priyamada, for joining me to co-host this. And I'll go with Manish. Go ahead, Manish. Thank you. Thanks for taking time out and joining us. Hopefully, Sam will be joining us in some time. But you can start the session, Manish.
Well, good morning and good evening. Thank you very much for inviting me for this session on the new criminal laws in India, which have been implemented as of the midnight of 30th of June 2024. Why are they creating so much of consternation? Why is the opposition and why are jurists and lawyers across the country demanding that these laws be put on a hold, primarily because the implementation of these laws and the way they were passed have raised very, very serious questions which have a direct bearing on civil liberties in India. But before I go into the pros and cons, or rather a critique of these new criminal acts, a recap would perhaps be in order. The Indian Penal Code, the Indian Evidence Act, and the Criminal Procedure Code together form the trinity or the bedrock of criminal law in India. The Indian Penal Code was enacted in the year 1860. The Indian Evidence Act was enacted in the year 1873. And the Criminal Procedure Code was enacted in the year 1908 and then amended again in 1973. Together, these three laws have been interpreted extenso by every court in India, from a district court right up till the Supreme Court, and even before independence, by the federal court, which then became the Supreme Court of India, and subsequently even by the Privy Council in most instances, because appeals from the high courts and the federal court in certain cases would lie to the Privy Council, which used to sit in London. Essentially, if you look at the three new laws which have been now put on the statute books, out of the 511 provisions in the original Indian Penal Code, only 24 sections have been deleted and 23 added. The rest have been merely renumbered in the new Bharatiya Nyaya Sanghita, or the BNS as it is called in short. All 170 sections of the Evidence Act have been retained in the new Evidence Act, which is called as BSB, and 95% of the CRPC, that is the Criminal Procedure Code, the original Criminal Procedure Code, has been cut, copied, and pasted into what is now called the BNSS. As a result, what you really have is an extenso copying of the old laws. And just for context, the three new laws are called the Bharatiya Nyaya Sanhita, which replaces the IPC, the Bharatiya Nagrik Suraksha Sanhita, which replaces the Criminal Procedure Code, and the Bharatiya Sakshya Bill, or the Bharatiya Sakshya Act now, which replaces the Indian Evidence Act. So the question is that if this is merely a cut, copy, paste, then why is it raising so many concerns? Why is it raising so many hackles? And why is there a demand that these new laws be put on a hold? Primarily, there are a couple of reasons for that. The first reason is that into these new laws have been extrapolated provisions, which I will deal with in some detail uh, after this, which constitute a very fundamental assault on fundamental freedoms and civil liberties. They fly in the face of many Supreme Court judgments, which, as I earlier pointed out, have interpreted these provisions. Number two, this now creates two parallel systems of criminal jurisprudence in India. So all matters which have been registered either in the police stations or they have been charge sheeted and they have been put to court up till midnight of 30th of June 2024 are going to be adjudicated as per the old laws. All matters which have been registered, all will be sent to court after 12:01 a.m. or 12 midnight 1 second, would then be adjudicated under the new laws. As we stand today, there are about 3.4 crore, which is about 34 million cases, which are pending in the judicial system of India. Most of these, or substantially an overwhelming majority of them, are criminal in nature, or they emanate out of acts which have been committed as offences or alleged offences under the Indian Penal Code. So, therefore, this duality is going to create an absolute nightmare, because each and every provision of the new laws would now have to be reinterpreted by the courts. The settled jurisprudence on those provisions which have been extrapolated uh, completely verbatim would then have to be reinterpreted and relaid down that this applies in its entirety to the new provision, or in the alternative where new provisions have been introduced, those provisions would also need to be interpreted by the courts of law, because law is not only a provision in a statute book, it is also the judicial interpretation which is provided to it, and the precedents which are set, the the various legal conventions which then emanate out of it. What then are the specific provisions, specific problems which the three new laws which have been implemented as of the 1st of July 2024? The first is that when you set the criminal law in motion, it is set in motion by the registration of a first information report. Now, the Supreme Court of India, in the matter of Lalita Kumari, had very clearly said that every complaint has to be registered as a first information report. So, therefore, they took away the discretion of the police completely, because, as I was earlier pointing out, that these laws are going to be now implemented in 13,000 odd police stations across the length and breadth of India, out of which about 7,500 odd are in rural India, about another 4,000 are in urban India, and 2,000 odd are special police stations. So, therefore, in order to ensure that everyone has access to the first ladder of criminal law, it was mandated that every complaint will be registered as a first information report. Now, what this law does is that it gives discretion to the police under section 173.3 of the BNSS, which is the new criminal procedure code, that in offences where punishment ranges from 3 years to 7 years, it would be at the discretion of the police whether to register an FIR or not register an FIR. The practical implications of this would be that those who are disempowered, who are marginalized, who come from weaker sections of society, who live in far flung rural areas where communication, even today, is an effort, they will really be at the tender mercies of a police station in charge, who is usually an assistant sub inspector or a sub inspector of police, in some cases, an inspector of police, whether his complaint would at all be registered as a first information report, which sets the criminal law machinery into motion. The second big problem with this is that in India, the jurisprudence which had been laid down by the eminent jurist and former Supreme Court Judge Krishna Iyer way back in the 70s was that uh, would be there would be bail and no jail. Unfortunately, this jurisprudence has been turned on its head over the past couple of decades by courts in India, where jail seems to have become the rule and bail seems to have become the exception. But the law as it stands is that if you are arrested by the police, they can take your custody for a maximum period of 15 days, simultaneously in one go. Or maybe you take it for 5 days, extend it by 3 days, but it can't go beyond 15 days. And after that, you're sent to judicial custody, and if you clear what is called the triple test for bail, your chances of getting bail on the 16th day are eminently very high, or maybe in the next 4 or 5 days, 10 days. What the new law does is that it allows the police to take custody of a person for a period of 60 days in case of minor offenses, and for 90 days in case of major offenses. Essentially, what it is that your police custody will be 15 days, but it can be spread over 60 days for minor offenses, or it can be spread over 90 days for major offenses, which means that whenever you apply for bail within that 60 or 90-day period, respectively, the police can say that you are wanted for investigation. So essentially, even if you clear the triple test for bail, your chances of getting bail before 60 or 90 days, respectively, are very remote after these laws have been implemented. And this is a very, very serious concern for all the 15 lakh lawyers, or the 1.5 million lawyers who practice across the length and breadth of India, from district courts right up till the Supreme Court. The third major problem is that in the case of Sunil Batra versus Delhi administration and Prem Shukla versus Delhi administration, way back in the early 70s, the Supreme Court had said that you cannot handcuff an under trial, that when he has to be brought before the court, he will not be brought in fetters. Primarily because it was felt that putting a person in fetters or handcuffing him or her is a serious assault on his human dignity. What this law does is that under section 43.3 of the BNSS, it essentially brings back handcuffing. That in certain instances, the police will be permitted to handcuff the accused, which then is really at the subjective discretion of the police, whom they consider or what offense do they consider to be used for handcuffing a person. And there is a fear that this would be misused against uh, political opponents, against people who speak up for civil liberties, essentially in order to degrade them or in order to humiliate them more than anything else. The third, the third problem or the fourth problem with these laws is that the Supreme Court had actually put the law on sedition in this country on hold. Sedition had been used in order to proscribe free speech or the fundamental right to speech and expression. Now, what this law does is that it brings back the law on sedition and defines four kinds of activities which would be considered seditious. They are subversive activities, secession, separatist activity, and endangering the sovereignty and unity and integrity of India, and armed rebellion. While on the face of it, nobody can have a quibble with this. But the difficulty is that all these four situations are not properly defined. They are not properly delineated. So, therefore, what constitutes a subversive activity? Would a speech constitute a subversive activity? Would a speech constitute a secessionist activity? Would it be seen as endangering the unity and integrity of India? Would a social media post tantamount to the same thing? Would, let's say, a comment made during a television debate really be come within the four corners of these four definitions? There is a lot of play in the joints. So therefore, there is a lot of scope for its very uh, very leisurely interpretation, if I can put it in these in those terms. Then next, the definition of terrorism has been incorporated in the BNS. Now, there is a standalone law to deal with terrorism in India, which is the UAPA, the Unlawful Activities Prevention Act. When you extrapolate the definition of terrorism, or you make terrorism an offense under the general law, when there is a special law in order to deal with it, the intent as to why do you choose to do that is not very clear. Fundamentally, for the reason that if somebody has to be charged for an alleged terrorist activity or a terror offense, there is already a law which exists, which is stringent enough for him or her to be charged. So, therefore, when you extrapolate that into general criminal law, it lowers the bar as to how the section pertaining to terrorism, which is section 113 of the BNS, can really be used by the police, and in what situations it can be used. Seventh, there has been a raging debate in India with regard to capital punishment. The courts have ruled that capital punishment should be used in the rarest of rare cases. But in these laws, which have been implemented, three more capital punishments, six life sentences have been added, which then opens a very big debate as to whether the purpose of criminal justice is retributive or it is a reformatory in India. So, therefore, I have tried to just list out some of the issues which are problematic in these laws. And this is only illustrative. This is not exhaustive in any sense of the word. I can actually go on chapter and verse with regard to many, many more such provisions, which are extremely problematic and will create a nightmare when they actually start getting implemented. Suffice to say that these laws were introduced in Parliament through a supplementary agenda. So, therefore, there wasn't enough time available to parliamentarians to object to its introduction because public order and police are state subjects under the Indian Constitution. The seventh schedule lists 2, entry 1 and 2. And these laws have to be implemented by the state governments. Even though the Criminal Procedure Code, IPC, and the Evidence Act do fall under the concurrent list, which means that the central government can make laws with regard to these three areas or these three domains. But the fact remains that since this has to be implemented by the state government, whether the state governments were completely taken on board, whether there was enough consultation done. And this does not seem to be the case because many chief ministers had written to the prime minister objecting to the implementation of these laws. Then, when these laws were referred to the Parliamentary Standing Committee on Home Affairs, there were many people who had recorded a very informed dissent, people who've spent long careers in the courts of law. And those dissents were really not taken on board when the laws came before Parliament. And finally, the icing on the cake was that they were passed in Parliament when a record 146 members of both houses of the Indian Parliament, the House of the People and the Council of States, respectively, were suspended for demanding accountability with regard to a security breach, a serious security breach which had happened in the House of the People on the 13th of December 2024, which happens to be the anniversary of the attack on the Indian Parliament on the 13th of December 2021. So, in concise, I have tried to give you a background of what the existing laws were, contextualize as to what is the problem with the current laws, and also as to how they have been passed in great haste, and they will ultimately end up becoming a problem as we go along. I am not very sure whether the vires of these laws has been challenged as yet in the various courts, but I do think that that would definitely become the case once these laws have now come into implementation. So I have taken about 22 minutes and 30 seconds of your precious time, and I would stop here. And I would like to thank Mr. Pitroda and all his colleagues for inviting me to this interaction and for giving me a chance to present my point of view. Thank you.
Thanks, Manish.
Thank you, Manish.
Really appreciate your joining us. Greetings, friends. I'm sorry I was a little late today. I couldn't make my tea on time, so my apology. Good to have Manish with us. Manish is an important leader in our Congress party. Manish was Minister of Information and Broadcast during Manmohan Singh's government, and he is really qualified to address this particular issue. This issue has become very important mainly because it seems to an average person one little unnecessary change, and two, it's a little stricter than what it ought to be. 60 days without any discussion, debate, to be in custody is just not fair. Though I don't understand all of the details, Manish has explained most of them today. I remain worried that poor people will be harassed, and I just don't see the need for this change. And that has been my concern. I hope we can open up for a broader conversation. The other concern is I don't know how they can push something like this without any proper debate, discussion, developing some consensus, taking into consideration opinion of other important people. And this is alarming to many of us. Time will tell how this thing plays out, but knowing their mode of operation, how they use laws to sort of take revenge on and off is of great concern to many of us. I hope people speak up on this. I hope there is more conversation on this. And something happens in the parliament with regard to implementation of it. Thank you, Sean. Thank you, Priyamvada. And let's open up for a broader conversation.
Sure. Thank you, Sam. Thank you, Manish. It was a great introduction. Thanks for taking time out of your busy schedule. So I have this first question from myself. So in the previous, at least code, people can take custody for 15 days, police, and can interrogate a person and arrest. So now they are going for 40 to 60 days, and this is the one of the primary worry for anybody and everybody. So what are your thoughts, Manish, on this particular aspect? Manish, you are on mute.
So the police custody would be for 15 days only. The difference is that it can be spread out now over 60 to 90 days. You see, earlier on, the police custody had to be taken in one stretch of 15 days. And it is not that you were remanded to custody for 15 days. The court could remand you for 2 days, then after that for 3 days, 5 days. But the total period was 14 days. And it was the first 14 days after your arrest. Now, this 14-day period can be spread out over 60 to 90 days. For example, you are remanded into police custody for 3 days. After that, they send you to judicial custody. You apply for bail. Moment you apply for bail, they will say, no, he's wanted in custody. So you are taken in custody for another 3 days. And then you are sent back to judicial custody. Your previous bail application is infructuous. Then you apply for bail again. Again, you can be taken for 3 days. So, you see, this can go on for 60 days in the case of minor offenses and 90 days in the case of major offenses. So, essentially, your ability to be able to get out of incarceration is going to become severely proscribed. So, that is the real concern. That even if you qualify the triple test for bail, that you are not a flight risk, right? You do not have a substantive criminal record. Your your you are grounded or rooted in society. So therefore, all that becomes immaterial if, let us suppose, the investigating officer insists that no, you are wanted for further investigation. So your liberty will get proscribed, uh, essentially, at least for 2 to 3 months in case of an arrest. That's the apprehension.
Awesome. So, and also, we know about the usual BJP's mechanism, interjecting many things through backdoor without much consensus. I think consensus is a word they are lacking in their dictionary. So, I want to also be knowing your perspectives on the previously there are imprisonment or fine for the minor offenses. Now they are trying to introduce this community services can be done instead of jail or fine. So this may be a global practice, and this may be really a reform, but at the outset it may look like, but we are only worried about the implementation of it and how they are going to utilize this, and there are not much definitions around where they are going to apply this community service, etc. So under the criteria, so there's not much consensus. What are your thoughts, Manish?
See, first of all, this is not really a Congress or a BJP issue, because these laws are going to be implemented equally in BJP ruled states and
Right.
non BJP ruled states. Right? So, therefore, these 13,000 odd police stations are across the country. So, essentially, you are putting a lot of latitude in the hands of police officers who are probably not even well versed in the existing laws which have been settled by judicial precedent over a period of time. and they more than often rely on coercive methods for interrogation, which is why even someone who may be otherwise a reputed or a well-known figure, thinks twice when he or she has been summoned to a police station. So the real problem is the latitude that it gives to the police officers. The second thing is that even with regard to all these provisions of community service, etc., now this is really in the hands of the judge concerned. And what kind of community service where, community service how is that going to be counted? How will that be a mitigating factor with regard to the sentence? These are things which actually need to be gone into in great detail.
Sure. I think somebody from LinkedIn saying thanks for you joining us, and she is also asking. Prasanna is asking, given the laws are now passed, what should be the way forward?
Well, essentially, the way forward is that these laws, as I say, uh, would obviously either be challenged on their vires or on their very constitutionality before the various high courts and the Supreme Court. I do not, as of now, know as to whether anyone has really done that. But definitely, once they start getting implemented and different provisions start going to court, the vires of each provision will then will then get challenged. So the short answer is that the remedy really lies in the court of law only.
Awesome.
Now,
Awesome.
or if the opposition is able to put enough pressure on the government to really pause the implementation of these laws, even though they have been notified, and they are brought back to Parliament for a rediscussion, uh, and these laws are re-examined by Parliament or a joint committee of Parliament. But then that creates a nightmare of its own, because you will have a anomalous situation whereby you had one legal regime till the first 30th of June midnight 2024, then another regime for a couple of months, then another regime, or the reinstatement of the old regime till the time the new regime is not reconsidered. So you've actually entered a implementational minefield.
But what was the need? What was the need to do it in a hurry and not
Well,
wait for the new parliament?
well, Sam, there's a question even before that. What was the need to do it at all?
Yeah.
And there is no clear answer to that. What was the need to do it at all?
I think the primary thesis they are trying to use to justify is all these are British era rules, and we are trying to reform. We are trying to bring on the lines of international other countries. It's not showing up in the name. It's not showing up in any of the acts or what they are going to.
No, essentially, see, if you wanted to really, again, it goes back to it goes back to the first principles of constitutionalism and criminal law. What is the objective of your criminal jurisprudence? Are you basing your criminal jurisprudence on the theory of retribution, which is that if an offense has been committed by somebody, so he or she must be punished in equal measure, which is an eye for an eye or a tooth for a tooth? Or let's suppose if you've robbed somebody, then your hand should be chopped off, or if you've killed somebody, your head should be chopped off. Or is the fundamental impulse of criminal law reformatory in nature, that you want to reform the person who has committed that offense, which then leads you into another discussion: how would you really like to structure your laws? And across the world, jurisprudence has evolved from being retributive to reformatory in nature. I know that in many countries, including the United States, the penal law is very harsh, and you can you have situations where you can be locked up and the key could be really thrown away. But then there are many other countries which have actually moved towards a far more liberal disposition when it comes to their criminal laws. Of course, post 9/11 across the world, you've seen a tightening of laws which uh, really have impinged in many more ways than one on civil liberties. So the question is, where does the the the, the balance lie? For example, the Patriot Act after the 9/11 attack, there was a lot of criticism, even among the legal fraternity in the United States of America, and I think many of those provisions with regard to how your personal communications can be interdicted or they can be intercepted, whether the same kind of latitude which is available to intelligence agencies abroad should be made available to them at home. If they are, let's suppose, pursuing a linkage which leads back to the United States. But a lot of them, that also got litigated and got settled, going all the way up to the US Supreme Court. But you did not lock, stock, and barrel throughout the US code, going back to whenever it was written. Here you have a situation whereby lock, stock, and barrel, you've thrown out the old criminal code. And with that, you have thrown out 150 years of judicial precedent, which had been interpreted and settled, as I earlier pointed out, by various courts at various points in time and at various stages. So every little and, or, shall, may, comma, apostrophe has been litigated extenso. And all that will have to be redone again.
Any more questions, Sean, from others?
Yes, Sam. In
Yeah,
fact,
let's do that.
I want both of you to respond to this. Ilamurugan N from LinkedIn is saying all four of you are from the same party. I think, don't you think your opinions will be biased? I want both of you to answer why it's more important as citizen and civil society of India. We are worried more than even members of Congress. Go ahead, Sam. Or I'll
No, I
start.
think it is not a party issue. This is really, a larger issue than party issue. That's how I see
Manish.
No,
political
I,
party.
I, I tend to entirely agree with what Sam is saying, primarily because, as I pointed out, that this is not a Congress or a BJP issue,
Right.
right? These laws are now going to be implemented across 13,000 odd police stations, and they are going to be litigated in hundreds of courts across the country, right? So, therefore, it really is that you are providing so much of latitude to the police that it the and you've done that without actually reforming the implementation machinery.
Right. Right.
The Police Act goes back to 1860. You've not rewritten the Police Act. You've not tried to sort of update the investigation techniques. You've not tried to actually uh, factor in the fact that there is a severe deficiency with regard to the population police ratio, right? You've not tried to factor in the fact that they have not really been equipped with modern scientific tools of investigation. And you've just decided to give that old machinery, which needs desperate reform, a new set of laws, which, for the lack of a better word, are more draconian and more frightening than even the previous ones.
Yeah.
In
Next.
fact, I have a question on the name itself. The Bharatiya Nyaya Sangita, the new penal law, Bharatiya Nagarik Suraksha Sangit, the new criminal procedure, Bharatiya Shaksha Adhinyam, new Indian Evidence Act. The name itself tells us some message. I don't know, I'm really worried. And I have one question before I go to Priyamata. Not question, maybe looking like a commentary. Prasanna is saying, given the route through courts will likely take a longer time due to the burden of cases and considering the strength of opposition, there is a reason for hope. As member of opposition, are there any plans underway to address this issue in Parliament in coming session?
Well, I had raised it on the 1st of July itself. Uh, I had given an adjournment motion on the 1st of July itself because Parliament did not sit on the Friday before that. as it got adjourned because the opposition wanted a discussion on the NEET exam. And then I raised it on the 1st of July itself during my intervention on the motion of thanks for the to the address to the president. But obviously, there was no response from the government. Neither did the Home Minister intervene in that debate. Neither did the Prime Minister choose to, address these concerns. So I now Parliament is going to be starting again from the 22nd of July. So I do hope that in that session we are able to address it more substantively.
Thank you.
Suresh Vallath is almost asking the same. Will India Alliance throw out the new Nyaya Singita out and bring back APC? Maybe I think this may be more leaning towards in case if we form government. I don't know. Manish, what may be our stand in case if we form government? Okay,
Well,
this may be an assumption question, but still wanted to ask.
well. You see, ultimately, as I pointed out, that a lot of it is old wine in a very old bottle. The problem is that the chilies which have been added to that wine are really going to sting. So the answer lies in actually reforming those aspects rather than really revoking those laws or the new laws, lock, stock, and barrel, and reintroducing the old regime. You see, because what happens in many cases is that it becomes a fait accompli. But then, of course, there have been situations like, for example, POTA was repealed, the Prevention of Terrorism Act, but the far more stringent provisions of it were extrapolated, lock, stock, and barrel into the new UAPA. So this would actually depend upon how the implementation plays itself out. But definitely, some of the provisions would have to be either amended or maybe even legislated out of the law.
Awesome. I'll hand it over to Priyamada. Thanks, Manish. Priyamada, you have any question?
Yeah, thank you, Sean. Thanks, sir. So my question, I have two questions, Manish ji. One is that is with so much power to the police, like even the judges are not able to decide like whether the case will go to trial. It will be the police now. Is India going moving towards a police state? And my second question is, how are the lawyers who have been like they have all the laws on tip of their tongues? How are they going to, you know? adjust to this new terminology which is more ever in like vernacular language? How are they going to cope with this? So those are my two questions. Thank you.
Well, number one, the laws are in English, right? So therefore, it's just that the titles are uh, are in Hindi or more Sanskritized Hindi, if I can put it in those terms. But there is definitely going to be a situation whereby every lawyer will also have to relearn the law, and you will have to actually sit down and really go over it provision by provision, actually put the old provision and the new provision together, see whether the old provision has been adapted in toto or there have been amendments, what is the implication of those amendments. So essentially it's going to be a process of relearning for everybody, and I don't think that many states across the country are really prepared for that.
Yeah. And my second question was, are we going heading towards a police state with so much power to the police?
Well, you see, that is what is really worrying. You know, what exactly do you mean by a police state? One of the definitions of that is that you have an authoritarian government which then uses the police in order to quell dissent or in order to try and squelch uh, opposing opinion. But more importantly, as I was pointing out, that this is not going to be implemented by one government. This is going to be implemented by 28 different governments or 28 different police administrations and the 8 or 9 union territories across the country. And that is where the problem lies.
Manish, what is the view of the Chief Justice of India?
Well, he will only have a view, Sam, if it is challenged and it is before him. He obviously can't have a view. I mean, it is within the sovereign right of Parliament to legislate or to make laws. It is for the courts to really interpret them and on the touchstone of the Constitution. So the Supreme Court or any court will only have a view once it is before them.
Will Congress party take it to the court by any chance, Manish, in case if it is the government doesn't want to discuss in the parliament?
Well, I am not really qualified to answer that question because that really would depend upon the collective view and the collective wisdom of the Indian National Congress. But suffice to say that uh, the issue is serious enough that it should warrant the concern of everybody.
There is a perception. I think I'll ask. I'll share Suresh Falat's comment. There's a perception that the bottom line is whether the new laws and rules will make it easier, faster, fairer to deliver justice to the common man. So, is this perception correct?
Well, I don't think so. I don't think so. It is going to make it easier because, as I said, that you already have 34 million cases which are pending in the Indian judicial system, right? You have a very skewed police to people ratio. Then there are issues with how that police force is really trained and whether it believes or it even has the tools to carry out, quote unquote, what is called a scientific investigation. And so essentially, I do not think that these laws are going to make it easier for the citizen. In my estimation, it is going to make it tougher for the citizen.
Some long ago you suggested about how we can work towards resolving a lot of these pending cases towards a faster and efficient judiciary, having a mission mode operation. So, do you want to kind of recall upon on that? Because the current thesis is okay. We are trying to say pitch this as a reform in the judiciary to bring justice earlier or sooner. So, what can be done actually in the current
Well,
system itself? Go ahead, Manish.
well, you see, when you say a faster solution, that faster solution cannot come at the cost of justice. Okay, so what you really require is to spend more on your judicial infrastructure. What you really require is to spend more on your uh, on recruiting more judges. What you need to do is actually increase the footprint of your police, but ensure that they are trained in humane and scientific policing. So, therefore, these are a set of reforms which need to go across the board and they require money. And as I was earlier pointing out, that public order and police are state subjects, and some of those states are so cash strapped that they are barely able to pay salaries. Their debt to GDP ratios are so skewed. Punjab being an example, Kerala being another example, right? Some other states being another example. So ultimately, it all fundamentally boils down to whether you have the will, and number two, you have the resources to be able to actually ensure that you can deliver speedier justice, but or a more expeditious uh, disposal of cases, which
I
does
think
not
that's the main
compromise
issue.
justice.
I feel that is the main issue. If you have 34 million court cases pending, it says it all.
Yeah, yeah. So I'll relate an anecdote to you. So my maternal grandfather, was a barrister, and so when I finished class 10th, so I happened to be in his house, and that is where currently I am because I live there now in Chandigarh. And so he came back from the court, and he asked me, "How did your exams go?" And I told him I got an X percentage. So then he took me to his club for lunch, and he asked me, he says, "What do you want to become?" So I said, "I want to become a lawyer." And he said something prophetic which has stuck with me ever since. He says, son, do remember, in courts, they make decisions. They don't render justice. अदालतों में फैसले होते हैं, इंसाफ नहीं होता. So there is a fundamental distinction between deciding a litigation and whether that decision really delivers justice.
Awesome. Actually,
Premada?
there was a great anecdote. So, in fact,
Premada?
since you mentioned barrister, so now there is even a new direction towards allowing people from foreign countries operating in Indian courts. So, what are your thoughts? I think previously, at least, there were a bunch of restrictions or otherwise. So, what are your thoughts actually on that?
See, this has been a point of resistance with the bar councils for a very, very long time. And the feeling is that if foreign lawyers come in, that would constrict the space for Indian lawyers to operate. That fundamentally it boils down to that. But if you ask my personal view, I've been always of this view that reciprocal arrangements help Indian lawyers equally. You have a large number of Indian lawyers who are now practicing in in the UK or in Canada or even in the US, but they obviously have to go through the bar exams and get their licenses afresh. But if there could be a reciprocal recognition of degrees, and where the judicial systems are complementary, for example, the judicial system between India and the US is not as complementary as the judicial system between India and Great Britain is. I see no harm in allowing Indian lawyers to go and practice in those courts and foreign lawyers from coming here. I think it would just make the environment much more competitive, uh, and it would make everybody uh, make everybody, I guess, read more and be up to speed, and be all there, as they say.
I think this reciprocity aspect, what you said, may open up a lot of avenues for our Indian lawyers in case if the other jurisdictions are willing to open up. I think it may be a great idea, Manish. Thanks. So I
Let's
think
take some more questions. We have
yeah,
very little time left.
we are on the top of the hour, Sam, and we can actually. There are not many questions. I think this is a very deep topic. There are very handful questions, but I think it was very meaningful. So, Priyamada, do you have any questions from the X space?
No, not from the X space, but sir, I would like to ask you, what would be your, like a reform to expedite these cases? Like, what you would be your suggestion, where the common man, gets justice like quicker, and not like because the cases they pen for years and years, and so that is one of the big problem where the middle class people don't go to courts. So, what would be your suggestion, like if you?
Well, you have to spend more on your judicial infrastructure. I mean, the short answer is that without spending more on your judicial infrastructure, there is no shortcut to it.
Awesome. So we have
Thank you.
371 viewers. I think there may be a bunch of them also who have joined from X space. So usually we have a lot of viewers after the call, Manish. Thanks.
Would citizens paying more for their case help in settling earlier?
Well, you see, there has always been this dilemma with the courts. You see, when high value litigation gets fast tracked, it leads itself to a question that just because you have more money, that does not mean that you should have quicker access to justice. So this is a very it's a troubling question, because you see, with a lot of high value commercial litigation, time is of the essence, because the meters are ticking with regard to
Right.
projects or interest payments, etc.
Exactly.
And obviously, if you are moneyed, you can hire better lawyers who have greater face value in court. Their ability to be able to persuade the judges that there is an urgency in the matter. Obviously, to that extent, may get uh, a more serious
But then
hearing.
that money can be used to improve infrastructure. That money
Well,
can be used.
yeah, but you see, but then again, let's suppose if you start actually levying court fee by the stakes involved in a matter, that itself is going to become problematic, because in many cases, the amounts involved may be huge, right? But the concerned companies may not really have the ability to then be able to pay those court fees. For example, a large number of real estate firms, when they go into insolvency and bankruptcy, that ends up creating a problem. And so, therefore, if they have to go against their own lenders, they won't really have the money to be able to afford the court fee. So these are issues, Sam, which actually have never been thought through over all these years, because the entire effort has been to firefight on a daily basis.
Manish, will the prevailing cases be heard under IPC or the new BNS? And also, for many years to come, do we have to live with these two new systems? In case,
Yes, you will have to, because till 30th of June midnight, whatever has been registered will be prosecuted under the old regime. After 30th June, the new regime. So you'll have to live with the old regime for a very long time.
Sam, you have any passing thoughts? Manish, you have any closing thoughts?
No,
The,
well, my only closing thoughts are that this is a very, very serious issue, and I do hope the political class in India realizes that the bedrock of any robust democracy is how liberal or how draconian your laws are. And therefore, there is a very thin line which separates a democracy from becoming quasi authoritarian without really having to change its fundamental character. And we should not be heading down that route. That's that's what I would like to say as I kind of sign off and thank all of you for having us.
Thank you.
thank you, Manish.
Thank you,
Really
sir.
appreciate
Thank you.
your joining us.
Thanks,
And
Manish,
Great.
for taking time out. Thanks, Sam, for getting
Thank
Manish
you.
on board for us.
we do this every week, Manish. And the idea is to bring in different people, different subjects, and we get a lot of interesting young people join us and participate. So thank you for coming.
Thank you very much, sir. Thank you.
Thank you.
And wish you a
Thank you.
very
Thank
good
you.
morning and a great day.
Thank
Thank
you
you.
too.
Thank you.